The following presentation will address topics dealing with employment law. I will address 2 or 3 issues that might typically be found in a chapter on labor law, and I think, as I recall, the chapter on labor does address some things like employment at will, exculpatory agreements, specifically non-compete agreements, and right-to-work laws. I'll address those issues first, since they are a little bit separate from what's typically referred to as employment law. Labor is when you're looking at issues related to unions, and since it has some information on employment at will, I'll refresh your memory on that. Remember, employment at will says that unless I have an employment contract that says something to the contrary, I, the employer, can terminate an individual for any reason, no reason. I can make up a reason. I can even lie about the reason. I'm not saying that's the right thing to do, but we all know that sometimes employers don't want to tell you why somebody's being fired. They don't want to tell the person to their face. They'll make up something like, we've got a little cutback in employment, or we've got a little downturn in the economy, store sales are slow, whatever it is. They don't want to admit that they just don't like that person any longer and they want them out of their sight. So they can lie about the reason, but what they can't do is terminate you for an illegal reason. And of course, the burden is on the terminated employee to prove by a preponderance of the evidence that the reason for termination was illegal. And we'll look at those illegal reasons in just a few minutes. Also, remember there's some limitations, some exceptions on employment at will. You've got the implied contract exception, you've got good faith exceptions, and public policy limitations. So take note of those. If nothing else, just refresh your memory on those. Non-compete agreements, they are enforceable in Tennessee, and essentially those are agreements that employers often want their employees to sign, and that agreement says something generally like, employee hereby agrees that he or she will not go to work for a competitor within a 50-mile radius after their employment has been terminated with ABC Incorporated. An employee agrees that this agreement will be binding for a period of 2 years. That's the limitation in Tennessee, generally a 2-year limitation on those non-compete agreements. And so you need to pay attention to what those are, because some states simply don't allow non-competes, but because Tennessee is one of many that allows non-competition agreements, then you want to pay attention to those, because many employers are using those in their employment contracts now. Another topic to pay attention to, and this is something that I often have phone calls on this issue. In fact, my first week after I moved back to Tennessee, I had a call from someone, and he was telling me that he had been employed for, it was double-digit years. Let's just say he had been employed for 10 years, always gotten good evaluations, and his employer had just fired him for no reason. And this is the key point here. Then he follows that comment up with the statement that they can't do that, can they? Because Tennessee is a right-to-work state. What that individual is doing is confusing right to work with employment at will. He's thinking that right to work means you have a right to a job, and right to work means nothing of the sort. Right to work laws, and he is right in that Tennessee is a right to work state. Right to work laws say that an individual has a right to be employed without being forced to join a union or pay union dues. And that's generally the rule of law in the bulk of the southern states. In fact, I don't think there are any exceptions in the southern states. From Tennessee southward, I feel pretty safe in saying that it's uniformly right-to-work states. And that's not true when you go north. But you need to note what right to work means. Right to work does not mean anything, does not have anything to do with your right to a job or the employer's right to terminate you under certain conditions. Again, it just means that you have a right to be employed without being forced to join a union. And those are the most important topics. Now, certainly there are, the chapter is important, but those are the most important topics in the chapter dealing with labor law. Now, the chapter on employment deals primarily with what I would generically refer to as fair employment practice legislation, things like age discrimination, disability discrimination, those sorts of things. This is one of those chapters, the one on employment law. It's one of those chapters that really you need to know it all. I would not exclude anything from that chapter. In fact, the checklist that I have for this chapter, I don't think you could really refer to it as a checklist. The checklist essentially just says you need to know it all, much like the chapters on tort law and contract law. But one of the most important items to pay attention to in this chapter is the Americans with Disabilities Act. And note the very broad definition of disability. There's a three-part definition. The term disability, as it's used under the ADA, means a physical or a mental impairment that substantially limits one or more of an individual's major life activities. Major life activities are things like walking, talking, seeing, hearing, those sorts of things. All right, so it's either a mental or physical impairment. Secondly, the second part of the definition says a disability is where you have a record of such an impairment as I just described. So you don't currently have the impairment, but you have a record of such an impairment. Maybe 5 years ago you had to seek psychological counseling and you went through some therapy to help you deal with some mental issues, but currently you're okay, but you have a record of an impairment that substantially limits one or more of your major life activities. So if you simply have a record of an impairment, you can be disabled under this particular body of law. Well, what if you don't have such an impairment and you never have had such an impairment? Can you still be disabled? Yes, because the third part of the definition says that if you are regarded by others as being disabled, that you are deemed to be disabled under the Americans with Disabilities Act. So that three-part definition is very important. Note that the law only applies to a qualified individual with a disability. Excuse me. So you have to be otherwise qualified to perform the duties associated with the job. And either with or without an accommodation, you can perform the duties. So if you're otherwise qualified, and again, who with or without a reasonable accommodation can perform, the law says essential functions. You have to be able to perform the essential functions of the job. So that means that there might be some duties, some peripheral duties associated with a job that you can't do. And if that's the case, if you can perform the job and you simply need some sort of an accommodation, and there are a couple of duties, minor duties, that you can't perform, the employer may well have to eliminate those duties from the job or transfer those duties to another person. That would be deemed a reasonable accommodation. Note that under this law, there are really two aspects to the Americans with Disabilities Act. One aspect of it says that you can't discriminate against a person on the basis of their disability. The second part of the law essentially says that if a person is otherwise qualified and can perform the essential functions of the job, the employer would then need to offer a reasonable accommodation reasonable accommodation. Notice the term reasonable. You can't require the employer to vastly alter the duties associated with that job, because then that would be deemed an undue hardship. So the employer must reasonably accommodate, yet they need not suffer an undue hardship. That's one part. The second part is you cannot discriminate against an individual on the basis of their disability. The definition of disability is very broad. It's also worth noting that the Americans with Disabilities Act was amended. Those amendments took effect in 2009, and now just about anything is a major life activity. If you have some sort of an impairment associated with your circulatory system or respiratory system, more likely than not, that would be a disability under the ADA. The definition has expanded tremendously. At one time, actually when the law was originally being passed back in roughly 1990, Congress found that some 50 million Americans were disabled under the ADA. And I would speculate that that number has increased by tens of millions as a result of the ADA amendments. And again, because the definition of disability has been expanded tremendously due to those amendments, I would venture a guess and say somewhere 60, 70 or more million people are now disabled as defined under the Americans with Disabilities Act. This chapter is one that covers a lot of topics, and one way that I've tried to make it a little more organized is by giving you a pre-employment inquiry guide. If you will read that guide to pre-employment inquiries, what I'll do in class is we'll probably start the first class meeting out reviewing that pre-employment inquiry guide. I would expect that to be read before you get to class, certainly. And then we'll go through it section by section, category by category. And if you have any questions, you want any clarification on any of the topics addressed in that guide to pre-employment inquiries, we will deal with that as we go over those topics in class. At a minimum, students will often ask me, do I need to know the laws? Just yes, you need to know the laws. You need to know what's prohibited, who is covered, and exactly what the law prohibits. For example, Title VII applies to employers with 15 or more employees. It prohibits such things as discrimination on the basis of religion and race and those sorts of things. And so you want to look at the law, at least have a general understanding of what it prohibits, and we will look at those topics. Gender certainly is another topic that falls under Title VII. Employers are prohibited from discriminating on the basis of one's gender. And certainly under that umbrella, we will address the subject of sexual harassment. As you're reading the chapter, note the two different types of sexual harassment. One is referred to as quid pro quo, and the other is hostile environment. We'll look at those two types of discrimination, and we will look with some degree of detail at the topic of sexual harassment. Most people think because they know, they've read about it in the newspapers, that they know generally what sexual harassment is. There's a lot more to it than what the average person knows. The different requirements on the part of the courts as to what constitutes a valid claim of sexual harassment. How do you determine whether or not the harassing conduct was offensive? Does it matter that the individual complainant voluntarily went along with the conduct that is now being complained about? Is voluntariness an issue, or is some other issue more pertinent to determine whether or not a valid claim of sexual harassment is being presented to the court. So we'll look at sexual harassment. We'll probably spend a half hour on the topic and break it down into its components and look to see exactly what constitutes a valid claim of harassment. As you're reading the chapter, I'm pretty sure it's brought out in the chapter, note that it is possible to have a claim of sexual harassment where the parties involved are of the same gender. At one time, that wasn't true. But certainly the current law is that if the parties involved, both the complainant and the harasser are of the same gender, that is a valid claim of sexual harassment. So we will cover that, and if you have any questions as you're reading through the chapter, it would be beneficial, certainly on this chapter, since we're covering the entire chapter and really not omitting anything. As you read the chapter, if you have any questions about topics, I just thought of another subject area where people often have some confusion. Disparate treatment versus disparate impact. Pay attention to that. That's important because employment discrimination will generally fall under one of three categories, no matter what it is that you're claiming, no matter what the basis of your complaint. Generally, it will either fall under the heading of disparate treatment. Disparate treatment is generally referred to as intentional discrimination. You have disparate treatment. You have disparate impact, sometimes called adverse impact. That is the unintentional type of employment discrimination. And then thirdly, the type of discrimination I referred to a few minutes ago with respect to disability discrimination, and that is where an employer fails to reasonably accommodate the employee. Certainly that type of discrimination can arise under the topic of disability, and it can also arise when an individual is filing a complaint based on religion. So both with religion and disability, an employer can be sued for failure to offer a reasonable accommodation. But remember, the employer need not suffer an undue hardship, and that applies both for disability discrimination and discrimination based on one's religion.